Hello everyone, I am Rusha Mukherjee, a student of FOUNDER-LEXIS Law College and presently interning with LEXIS and Company. Today I am going to discuss a very interesting topic, that is the anti-conversion law and the laws that govern whether a person can convert his religion or not. For this, we must remember of the two personalities, that is A.R. Rahman and Dharmender. We knew that A.R. Rahman has changed his religion and Dharmender also changed his religion, but Dharmender did it with the intention to marry for a second time. Now, when we are talking about the anti-conversion law, what does it mean? Does it mean that a person cannot convert his or her religion? No, it doesn't mean so. It only means that a person cannot be forced to change his or her religion. The conversion of religion has to be completely voluntary. Because there was a time, especially in the pre-independence time, when people were being forced to convert their religion, sometimes to Muslims, sometimes to Christianity, and hence the religions of many people were at stake, and hence the need of the anti-conversion law was felt. Already there are 8 states in India that have the anti-conversion law, like the Odisha and Arunachal Pradesh, all these. Now the question comes that in these states only why the anti-conversion law is there, because till now the right to religion, to propagate religion or the anti-conversion law comes within the state list and it cannot be regulated by the central. Now it is a huge matter of debate that whether it should be controlled by the state or whether it should be controlled by the center. And hence any of the anti-conversion laws till now is not applicable to the entire country. Now anti-conversion law also gives some threat. Like by using this, many persons was stopped from converting to Christianity or to Muslim community. Now if we have to ask the question that if a person wants to marry more than once, and for that sake, if he changes his religion, will that be held valid under law? That question was answered in Sarla Mudgal case. The Supreme Court answered that that conversion will be invalid because of the fact that this conversion had no faith in it. It was only out of the interest of committing polygamy. So, even if it has been voluntary, no force have been applied, nothing of that sort have been done, but still that is invalid because this has been done with some malefied intention and no faith was there in it. The first state who implemented the anti-conversion law was Odisha. Now it is very difficult to balance the right to propagate religion and the right or the fact that they try to force somebody else to convert into their religion. Regarding this, in Refs versus Madhya Pradesh, the court opined that free propagation is a basic fundamental right, but there is no right to compel anybody else to your own religion. You cannot compel anybody else into your own religion. Now, many of the universal nations' rights, many of the United Nations Universal Declaration of Human Rights says that religion is a basic fundamental right of people. Now, how can we convert our religion? We have to give a notice prior 30 days to the district magistrate, and the district magistrate can restrict or permit the religion conversion. But sometimes we also find that the administrative authorities try to interfere in these matters. So that's all for today. But I would like you to comment that whether the anti-conversion law and the right to propagate religion should be kept under the domain of the center or with the state. And if it is given to the center, will the basic structure of secularism of the country be alive? Please answer in the chat box. That's all for today. Tata, bye bye, have a nice day, and thank you.